Good morning, everybody, and welcome to the DC Court of Appeals. We have 3 cases on this morning's regular calendar, and we will start with number 23 CF 859, DAVON Johnson versus United States. Whenever you're ready, Ms. McDonald.
May it please the court, Sarah McDonald on behalf of appellant DAVON Johnson. I'd like to reserve 2 minutes for rebuttal. This court should reverse the denial of the motion to suppress because the Secret Service lacked probable cause to believe that Mr. Johnson not only was aware of, but constructively possessed a firearm in an SUV he was not in. The government's argument for probable cause rests entirely on the theory that officers could reasonably believe Mr. Johnson was part of a common enterprise. The government's attempt to expand Pringle to these facts fails for 2 separate but related reasons. First, the government does not show that gun possession leads to a reasonable inference of jointly conducted activity or a common enterprise. And second, the government's efforts to argue that the driver would not have been willing to let Mr. Johnson into the SUV unless he were possessing a firearm do not comport with common sense, ordinary experience, or this court's case law. I want to unpack the idea that having these guns in the car was the sort of obviously criminal activity that means someone wouldn't be allowed in the car unless they were possessing the guns on 2 levels. One specific to the facts here, and one broader as to gun possession as a purported criminal enterprise. As a factual matter, the government's argument rests on the idea that the map pocket gun was not hidden. It was in plain view, and so Mr. Johnson would have seen it as soon as he got in the car. But he didn't get in the car, so the government's argument all rests on inferences drawn from the driver's behavior. What it means that the driver—
But what Pringle allows the police to do, right? Pringle says, look, you look to see whether the driver would have let someone in this car and draw an inference from that. And here we've got a car with, the gun in the, what we're quaintly calling the map pocket seat. And then we've got a gun in, also quaintly called the glove box. And then we've got a gun in the 3rd row of seats underneath a seat that's down. So it sure looks like there's guns distributed throughout the car so that people can get them easily to use them if necessary. And the person with the keys to the car is letting Mr. Johnson in the car. Can't we draw some inferences from that?
So first, I think because there's no indication that Mr. Johnson had even ever gotten in the car before, that's why the government turns on—
Why does that matter under Pringle, right? Because under Pringle, if I'm just following the analysis in Pringle of this common enterprise, the idea is, I'm just not going to let this person in the car unless he's part of my team, my crew, my common enterprise. And so maybe he hasn't been in this car before. And maybe he doesn't know before he gets in that the gun is in the map pocket, but he's part of my team. And so once he sees it in the map pocket, he'll know he's got a gun that's available to him. I think that's the rationale of Pringle.
So first, I want to come back to the idea that the driver thinks, well, once he sees it, he would be in on this, because I think as a factual matter, there's no reason to think that the driver is going to think that someone getting into the car for any amount of time for a trip of any purpose, we know nothing about the relationship between these men or why they were getting in the car. But as to Pringle, it matters that Pringle deals with drug dealing. And so what Pringle says is that drug dealing, the indicia of pending drug dealing in the car, bespeak drug dealing, an enterprise that to which a driver wouldn't admit someone to the enterprise unless he were part of it. And so Pringle talks about admitting someone to the enterprise. And when the enterprise is drug dealing, as soon as you admit someone to the car, you're admitting someone to this enterprise of drug dealing. And the government doesn't cite a single case where the enterprise is simple possession, and especially not possession of something like guns that are.
I don't understand why that matters. So like, help me out. If Pringle's rationale is you wouldn't, this guy who's sitting in the passenger seat without really immediate access to the 5 small bags of drugs in the back seat under the armrest, hidden. Pringle's core rationale seems to be you would not have let these guys, these other 2 passengers in the car unless they were privy to what was going on. They could be a witness against you, and you know that's a serious offense. Some possessory offenses are also serious offenses, including possessing ghost guns with extended clips, like the one that is in the back seat, or a serialized gun also with a rather extended clip, like the one in the mat pocket. So I don't understand why drug dealing is special. I mean, they're both serious offenses. The rationale that you wouldn't let somebody in and be a witness to such serious offenses seems to cross-cut both Pringle and this case. So why do I care that one's drug dealing?
It matters because there is an enterprise typically that multiple people are involved in that requires multiple people and that is like happening from the car. And so
where's that fact in Pringle? Who says they're dealing drugs out of the car?
So I think that Pringle has to be understood as a case in which the car is an instrumentality of the drug dealing. And that's because there is both actively a very large amount of cash and drugs in these individually packaged baggies in the car. And so Lefebvre, for example, understands this as a case that has to be understood as pending drug dealing, like someone who was dealing drugs much earlier in the day isn't going to leave this amount of cash in the car if they're going on about, you know, innocent business later in the day in the car with completely uninvolved people.
Counsel, I guess I'm just stuck on the words of Pringle, where the Supreme Court says that based on the facts that he's in the car, you know, with the drugs and the money, that there's probable cause to believe that Pringle committed the crime of possession of cocaine, either solely or jointly. So it's not that the court is saying that there's probable cause to think that he's possessing the drugs with an intent to distribute or that they're distributing drugs. It's just simple possession.
Pringle's holding, though, is that because
I think that is the whole, I mean, what's interesting about the structure of Pringle is that sort of that the court draws that conclusion and says there is probable cause for possession, and then responds to the defendant's argument of, wait a second, you're just finding me guilty by association with these other people in the car and my mere propinquity to the drugs, and then the court rejects that and makes this common enterprise inference, but the court's already said before that we think there's probable cause to think that he jointly or solely or jointly possessed the drugs.
And that's never explained by anything in Pringle except this paragraph about the common enterprise. And I think so that has to be understood as the rationale for why possession follows. And so someone who is part of a drug dealing enterprise, it's reasonable for officers to think that they
I guess
have.
I'm sorry, just to push back a little bit on your saying it's not explained. I mean, in the passage that I just was referring to, where the court says, look, there's probable cause of sole or joint possession, the court just goes through the constructive possession analysis and says, based on these facts, we think that, you know, there's reason to believe he had knowledge of the drugs and exercised dominion or control over the drugs. So what's not explained, I guess I'm not understanding.
I think commentators have understood, including Lefebvre, Pringle as a case where there's nothing to explain the idea that he exercised dominion and control, except for this idea that there's a common enterprise of drug dealing. But it also matters here, the government hasn't argued this as a case resting on anything other than a common enterprise. This case is different than Pringle in that Mr. Johnson was never in the car before. So the question all has to turn on, what does it mean that the driver is willing to let him into the
I guess
car?
that, I'm sorry, that's also where I'm a little bit confused, and I wanted to ask you and the government about this, but do you think that common enterprise is kind of its own standalone justification for probable cause, or is it just a component of constructive possession? I mean, the way that one could read Pringle, because of the structure that we just talked about, is that the common enterprise rationale is just a component. It isn't its own standalone thing. They've already said that he constructively possessed the drugs. So am I wrong about that? And if so, can you sort of unpack why you think Pringle gives some sort of common enterprise? I mean, if it's a standalone thing, then I start thinking about conspiracy and is there probable cause for conspiracy, but that's definitely not what Pringle is talking about.
No, I think a common enterprise is a way of establishing an inference that someone is aware of and intends to exercise dominion and control over contraband. So in this case, I think there's no basis simply based on Mr. Johnson's actions to think that he's aware of the gun. I think that's more how the analysis in the trial court proceeded, sort of the obviousness of the gun from outside, that Mr. Johnson would have seen it as he was getting into the car. And then what does it mean that he's going to get into the car with this gun? And that's sort of a rationale that the government has completely walked away from here. And so I think the government acknowledges that the only way that to show sufficient basis to believe that Mr. Johnson was aware of the gun, that he had the ability and intent to exercise dominion and control over any of the guns, has to come from what it means that the driver is willing to let him into the car. And again,
Can I add one other quality? It's not just that the driver is letting him into the car, but the three guns are positioned in a way so that everybody can have access to one, right? There's one in the glove box by the passenger seat. There's one in the map pocket, accessible to those in the second row, and there's one behind under a seat in the third row. So the thinking would go, without calling, it's not drug dealing, but what we're doing is we're getting in this car. And you wouldn't let somebody in a car with guns strewn about it and so haphazard away. Several, I don't know if I want to say plainly illegal. I mean, the two with the extended clips strike me as being plainly illegal just from on sight, but I don't know how plain that is to everybody. You wouldn't have let them in the car without the common enterprise that, hey, everybody, the guns are here, here, and here. Things go down, you can grab them. So what's wrong with that? I mean, and this is just a probable cause standard. We're not talking about more likely than not. We're not talking about reasonable doubt. An officer who sees the guns positioned with it that way and 5 people getting into the car, under Pringle, you could say, well, you wouldn't have let them in the car with those obviously illegal firearms unless you kind of had the intention to allow them to have access to all 3 of these firearms and everybody knew where they were and had some intention to sort of have constructive possession over them. What's wrong with that thinking?
I think it's wrong first as a factual matter. There's no indication, again, why the men are getting in the car, how long they'll be in the car. As trial counsel argued, this could have been a case where Mr. Johnson is getting a ride home, getting a ride to the bus stop from being out. And so the idea that the driver is going to think anyone who gets into this car for any amount of time is going to be aware of these guns doesn't hold up as a factual matter.
Can I pause you there? Same with Pringle. Why isn't the same thing true of Pringle? We don't know if they were dropping that guy off at the bus stop. Was there evidence about where he was going from and to? He was in the car when they pulled him over, maybe for only a brief moment.
He was in the car, and I think that's why drug dealing matters, that this is something that it's reasonable to think multiple people are going to be involved in this, versus I think when it comes to guns, it's perfectly reasonable to think, these are guns that individual people are possessing, and there's no reason specifically to tie that to Mr. Johnson. And so both because I think every indication here in the record is that the driver thought these guns were hidden. The driver left the car for an unknown amount of time, but at least half an hour with the gun stashed in the mat pocket. As the men are approaching the car with uniformed Secret Service officers surrounding the car, the driver unlocks the car and proceeds to get in. And when this court evaluates the photographs of the gun in the mat pocket, I think it's easy to see why the driver would have thought the mat pocket gun, like the other two guns, was hidden. And
I mean, it's definitely true that, I mean, I think the trial court's finding that he could have seen the gun before opening the door is out. I don't think the government's defending it. I don't think it's a defensible ruling. But again, my reaction to what you just said, so the driver thinks the guns are hidden. Same with Pringle. Those drugs are hidden. So I still, I mean, at every step, you know, as you describe what's going on here, I guess here's my reaction to this case is maybe Pringle's crazy. But the idea, if 3 people being in a car with 5 small bags of drugs is probable cause to arrest all of them because they must all be in on something criminal, then 5 people in a car with 3 guns strewn about it, 2 of which are plainly illegal, strikes me as more obviously probable cause to think that they're engaged in some criminality. So every time you kind of say, well, this isn't necessarily enough, I think, well, then Pringle's wrong.
I think one of the main differences here, I think it's real instructive to look at this court's decision in Conley, and coupled with this court has cases, in cases where possession of contraband is the purported criminal enterprise, even obviously illegal passengers, obviously illegal contraband that passengers were aware of, this court has rejected a Pringle inference. And I think that only is
Are you talking
more
about fireworks
warranted here. I'm talking
or
about
coca?
the fireworks, and Perkins, the open container.
Relatively innocuous, though. Offenses, possession of fireworks and possession of an open container, both, I assume, I know polka is a misdemeanor. I assume the fireworks are too.
The court in Perkins said that the possession of the open container was clearly illegal and rejected the argument that this wasn't obviously illegal activity. And so I think the government's attempt to paint that as relatively innocuous doesn't really hold up, but this court has sort of directly addressed the sort of common sense inferences around getting into cars with guns in Conley. In Conley, the court was asking the question whether this statute at the time that criminalized presence in cars with guns was constitutional, and said it criminalized behavior the average person wouldn't know is wrongful. And
Right, so, I mean, Connolly strikes down the statute that says that that's a crime to be a passenger in a car with a gun. But I just wonder, I mean, is the logical outcome of this argument that if guns are not so obviously illegal, you know, because of Second Amendment developments, are you arguing then that the police didn't have reasonable articulable suspicion to stop these men after finding guns in the car? I mean, how far does this go?
It's not an argument that we've raised. I think that the officers, based on what the officers believed to be a firearm, we haven't challenged the reasonableness of the stop. But I think that Connolly is particularly instructive here because it, like this case, deals in common sense inferences. And I
Right,
think,
but I guess my point is, like, there's a spectrum, and it's one thing to say, look, we're not going to let you convict someone of a crime of being a passenger in a gun, being passenger in a car with a gun. But that is very different than saying, okay, but if we think that you're a passenger in a gun and someone's letting you into the car where there are guns distributed throughout the car, you can't have probable cause to arrest that person. Those are just, and then there's the question of, okay, but if there are guns in the car, you know, do you even have reasonable articulable suspicion to stop them and question them? Does the presence of the guns in the car, you know, if they're not so obviously illegal, then maybe the police don't even have the basis to stop them and try to investigate. So I know you didn't argue it, but I'm wondering where your argument leads.
Yeah, I think that whether officers can recognize something as illegal, right, is a different question than would someone not even let a person into the car because of the obvious criminality, because they're so worried about talebearers or witnesses to illegal activity. And so Conley, I think, really is specifically relevant to that point about the obvious criminality. And Conley explicitly rejects the idea that guns in cars indicate common enterprises.
Do you have
And
do you have an analog like that where a case like Connolly can limit the force of a Supreme Court case like Pringle just because of the factual differences? You know, one is involving drugs and drug dealing, and maybe we'll say it may be the obvious, you know, some of Judge Steele's questions, maybe the obvious application of it would seem to come this far, but the Supreme Court has never applied it in this context. So can a case like Conley say, well, okay, there's Pringle, it says what it says, but as to guns, no, according to our case law, until the Supreme Court says otherwise?
so Pringle's common enterprise holding ultimately rests on these common sense inferences, right, about what inferences one can draw from the presence of certain contraband. And I actually think that both TH and Perkins are really analogous because those were cases, you know, in Perkins, the government is expressly pressing a Pringle argument and says, you know, it doesn't make sense that the driver would let someone in unless they're also possessing this. The court in Perkins at multiple points goes out of its way to say this just isn't the kind of case like Pringle where that inference makes sense. And that's just as a matter of common sense. And here we have not only common sense, but case law from this court rejecting the idea that guns in today's day and age are so obviously criminal that anyone getting into a car is going to know that it's illegal, that someone who lets people into their car is going to be so worried about it. And so I think Conley really supports what is ultimately like a common sense inference about what conclusions can be drawn from the presence of particular types of contraband. I see that my time is up, so if there are no further questions, I'll reserve my time for
Okay,
rebuttal.
well,
Thank you.
you have none to reserve, but we'll give you some time. So.
May it please the court. Good morning, David Goodham for the United States. With the court's permission, I'd actually like to try and address the question that Judge Easterly indicated she was going to pose to the government as well as my opponent. Pardon me.
I can't remember what the question.
The question is, quite frankly, I think it's a difficult one. I have a leaning towards an answer, but I'm not sure it's the exact answer that is apparent from the opinion. The question is, when you read Pringle, do you understand Pringle to stand for the proposition that if you have a constellation of facts that suggest a driver or another person in the car would be unlikely to admit others into the car because they would otherwise turn evidence against them, does that equal a common enterprise, and thus does constructive possession flow from the constellation of facts that equals common enterprise? Or do you have to go a step further as a government or as an officer thinking about probable cause and say, no, we have a conspiracy here? I myself, there are two features of Pringle that tend towards not the conspiracy take on that question. Number one, it would have been very easy for Pringle to use the phrase conspiracy. They obviously understand that terminology. Common enterprise comes from Wyoming v. Houghton, where Scalia used the phrase to describe the ability of officers to conclude that somebody might put something else in a passenger's bag. The other feature of Pringle that tends to lean towards, in my impression, common enterprise has special meaning in the probable cause context, because when you look at the language Your Honor focused on earlier, the court describes the facts and then says it is entirely a reasonable inference from these facts that any or all three of the occupants had knowledge of and exercised dominion control over the cocaine. And so what the court, I understand to be saying is that constellation of facts, then they answer the question, what does that constellation of facts mean? Later, they say that constellation of facts means there's a common enterprise. And what does a common enterprise means? It means an enterprise in which a dealer, in that case, would be unlikely to admit an innocent person. So I don't disagree with the notion that Pringle is a very difficult decision to parse. For the most part, Pringle, the cases after Pringle have gone down the road of drug dealing. And that's a very easy sort of, okay, well, that's a drug dealing case. We'll assume common enterprise from that. But critically, I think, pardon me, I think Perkins has answered the question that has been posed by my opponent.
Can we
I'm sorry.
stop on Pringle though
Sure.
for a second? I mean, it's a really weird case to say, weird being a technical legal term, to say that this inference arises where the police have done a consent search of the car. Right? I mean, to say, oh, well, no, the driver wouldn't let anybody in the car unless there was a common enterprise, but the driver's already let the police in the car on consent. I mean,
Sure. I
don't
think,
understand that.
well, I think in the consent case law, this court and the Supreme Court has said, oftentimes people do things and give consent when it's not in their best interest. And so I don't think.
And so ergo, oftentimes they let people in the car when maybe it's not a good idea to let them in the car.
Entirely
right?
possible.
I mean, maybe they just forgot, oh, shoot, I've got those 3 guns in the car and I just unlocked it for this guy that I don't know, or maybe the inference here, right? Like, we just have no idea what's going on. Maybe the 4 people in the car are about to rob Mr. Johnson, who's got all the fentanyl pills. Like, we just have no idea. And the guns are there because he's going to get in the car and they're all going to point the guns on him. I mean, I find it very, very strange to draw this inference based from Pringle.
Right. I don't disagree at all with the notion that we could posit a bunch of permutations on why the driver fobbed them in. But we're in the probable cause category, of course. And the probable cause category is reasonable belief of guilt. More specifically, probable cause pursuant to Illinois v. Gates allows officers to use their common sense understanding of how humans behave. And a common sense understanding of how humans behave in this context. To put it bluntly, this driver had a lot to worry about when he fobbed in those 4 other passengers. Number one, we've already discussed the firearms throughout the vehicle, 1 in each row. Number 2, we have extended magazines on every one of those guns. And, this court is well versed in what extended magazines are. This is an ongoing Second Amendment issue. But when you look at the photographs of
can I pause you there? Because I was is there any evidence that these magazines contain more than 10? There are pictures of their extended beyond the handle, but that's not illegal. High capacity magazines are illegal, and there's no evidence that either of these are high capacity. Is there?
Yes. No. The answer is no.
There was actually no testimony about them being extended, right? I mean, the only person who says they're extended is the trial judge, and the findings says they're extended, but I wasn't quite sure what she based that on. She didn't say. I did a word search for extended. It's just not in the transcript.
No, I think she might have been inferring. I mean, she might have been using common parlance when she used, because when you look at the photograph, they're clearly extended. This is not a manufactured clip that you shove into that firearm. I don't disagree for one moment with the notion that, we could have tightened that up and closed that loop. But again, we step back, we understand what we're talking about, which is officers on the scene looking at the evidence they had. And
do you mean when you look at the photos, do you mean the photo of it in the pocket with the outline?
No, the one where it's, the CSSOs have taken it out and put it on the seat, and you see, and that's true with all respect to all 3. But again, we're talking about officers who had an understanding that.
I'm sorry, just to pause. I can see the one in the map pocket. I can see the one under the seat, and they both have quite extended clips. I mean, these are pretty obviously 30-round clips, I think. But there's no evidence about it. You said with respect to all 3, I thought the glove box one was a serialized with a standard clip in it. We don't have a picture of that
Actually,
one.
I'm sorry to interrupt.
Okay, yeah.
But I've seen the photograph of that one. It's a variation on the theme of, and that was in the record. I can certainly provide it to the court. And then the court made findings.
But just that one is also an extended clip?
Yes.
Oh, I just don't recall ever seeing it. Okay, fair enough.
Yeah, and the court did, you will see at pages, pages, 84 to 85, she says, extended magazine from the map pocket, extended magazine from the pistol in the glove box. That's pages 84 to 85. But again, this doesn't all ride or fall on extended magazine, to the extent that, one of these was a ghost gun. None of them were registered, no licenses. Now, I understand that, somebody's not going to be in the back seat sort of checking the internet to figure out whether or not something was licensed or registered. But it's a piece of the puzzle when you're asking the question, given this constellation of facts, whether that driver would let them in. And then the final thing is, and actually this harkens back to a hypothetical posed here, the gun where Mr. Johnson was entering to sit in was directly behind the driver. So if you're not a confederate, an acquaintance, a friend of the driver, then the driver is exposing himself to significant safety issues when there is a gun. Literally, Mr. Johnson leans forward, pulls it out, and can assault either the driver or anybody else in the car. So
I mean, the guy sitting behind you in a car, my friend could, I have what do you call it? A lug nut wrench. Sorry, I'm losing the word. I have a wrench in my car behind my seat. My backseat driver. I let friends in my car sometimes. I let my kids in my car sometimes. If they wanted to, they could take that and clock me over the head with it. You think that's like, who cares? Yeah, your friend might shoot you just by letting anybody in your car. Maybe they brought their own gun, but that doesn't seem like a potentially incriminating inference that one could draw.
I think it's I think it's a relevant factor when we're considering not a lug wrench, but a gun with multiple rounds in it. But again, we're talking constellation of facts here.
Just going back to one specific fact, there actually isn't evidence that he was going in the car to sit in that seat, right? Because we don't know which side of the car two passengers were getting into the backseat door through.
Well, no, the officer Capasso said that Officer Whitehair communicated. Officer Capasso freely conceded he didn't see where Mr. Johnson was getting in. But Officer Whitehair told Officer Capasso before the hearing that he was getting in the seat, getting in the door, the seat right behind the driver.
Right, I understand that, but sometimes you have to move over to the middle seat when you've got three people sitting in the back row. And, to the extent we're drawing anything from this, we don't know if he was getting into the middle seat. We don't know if two people were on his side because you guys didn't provide testimony.
That's fair enough.
Okay.
That's fair enough. There's one point I'd like to make with respect to this court's own case law, and I think how it bears on Pringle. My opponent has talked about drug dealing. My opponent has talked about the fact that that's a necessary part of the equation for Pringle. But, I read Perkins to dispense with that. And what I'm talking about is Perkins, is a POCA. It was an open container of malt liquor, one can in the center console. And Perkins nonetheless applied the template that is Pringle to that POCA, to that malt liquor can, and they concluded for sure that that was not something that a driver would be loath to let an innocent passenger into, because, who's going to toddle down to the police station and rat out an open malt liquor. But critically, Perkins says at page 308, we would not employ comparable reason to infer a common enterprise between the driver and the passenger in the case at bar. But they entertained the possibility that Pringle applied to a malt liquor can. It was just that it wasn't so illegal a context that would have led the driver not to come in. So they didn't say, well, Pringle doesn't apply because it's drug dealing. They didn't say Pringle didn't apply because there was commerce.
Do you think they said Pringle absolutely did apply, or they were just like, even if it does?
I read Perkins, and granted, for sure, I'm reading between the lines.
Yeah.
I read Perkins for the proposition that they understood Pringle not to be confined to just drug dealing, but they concluded that Pringle did not apply in that case because, again, exercising common sense, no driver is going to be loath to let a passenger in when he's got sole possession of a can of malt liquor.
But can I get back to the initial question that you were discussing about how we understand Pringle and its discussion of common enterprise? And I think you were positing that, you know, it could mean, it could suggest conspiracy, but it doesn't suggest conspiracy because they would have used that word. But I think my question is a little bit different, which is common enterprise sort of its own standalone basis for probable cause, or is it just a component? It's just like one inference that you can use to establish constructive possession. Because I think at the end of the day, that's what Pringle says is, yeah, we think there was probable cause to think that he constructively possessed the drugs. And if that's how you read it, right, like you could say, okay, yeah, it's an inference that you can draw when there's contraband and not always, right? See Perkins, but you know, or TH. But then there's the question of like, how strong is that inference given the facts of the case? Like, don't we still do our usual Fourth Amendment super fact specific analysis where, you know, we look to all of the circumstances of the case to say, well, okay, you could draw this inference, but how strong is it in this situation? And where we don't have information about how these men were not related. I mean, the trial court only found that they were associated. She didn't find that they knew each other. They were just clearly walking together to the car. And just, I mean, looking at some of the other Pringle cases from the other circuits, there just seems to be just so much more context and color before other appellate courts have said, yeah, we can see a common enterprise here. I mean, this is sort of on the outside, the outskirts, pushing the boundary of the thinness of the evidence to find a common enterprise.
I see it as a spectrum, not so unsurprisingly, but a sliding scale. And I don't mean to be entirely facetious about that. The higher you get up on the spectrum towards one end of a plainly illegal, let's say there's a bomb sitting on a passenger seat. You know, that's an easy conclusion to draw that a driver would not let other people in because that would lead directly to state's evidence. The further down the spectrum you go, more to the middle, for example, and you're getting to less obviously criminal behavior, the can of malt liquor, the box of fireworks, then the inference of a common enterprise, and then the further inference of dominion and control.
Can I just clarify something just so I don't lose your point here? Was your first example a bong or?
Oh, I'm sorry, a bomb.
Bomb. Oh,
Yes. Yes, no,
Okay, gotcha.
yeah, in this day and age, bongs would not.
It makes a difference.
It's a variation on a can of
All
malt
right.
liquor in certain
glad I
settings.
asked.
Yeah, having been to Oberlin, I can't say that.
Okay.
But so a bomb, you know, that's an outlier for sure. And I'm not suggesting this is that case, but
sorry, just to refine my question, because I think I wasn't clear, perhaps because it wasn't clear in my head. You know, I think there's sort of the on-off switch of like, does the common enterprise inference actually apply, right? But then there's the question, even if it does apply, of how strong is the inference on these facts? And so one could maybe say, sure, the Pringle, you know, inference, common enterprise inference applies here, but it's still pretty weak because we just know so little about these people. I mean, I was looking at, I think it was a Seventh Circuit case where, you know, they used the common enterprise and it was that they had this person under surveillance and he made a phone call and then the car pulled up and, you know, he got in the car and the car was driving erratically and then they stopped the car and it smelled like weed and then they got them out of the car and then they, you know, searched the car and then, you know, arrested everyone and thought, okay, there's a common enterprise here. I mean, it looks worse than here where we start, just, 15 seconds before he reaches for the car door, and all we know is that he's associated with a group. We don't know how, we don't know that he's got somebody's phone number. We don't know, that he's called someone for a ride. We have no idea why he's with that group, what he's doing, what their relationship is. So even if the inference exists, beyond that, like, what else is there to establish probable cause? And I recognize that probable cause is not proof beyond a reasonable doubt, is not preponderance, but that's sort of
Sure.
my question.
Yeah, a couple points. Number one has been already discussed. We don't know anything about Pringle and his passengers. So, but I think I would also here differ a little bit with Your Honor's
But
suggestion.
we do know that Pringle got in the car, right? Like
He's there.
there is the possibility here that Mr. Johnson opens the car door, sees the guns and says, I'm out.
I totally understand that that's a
Right. And
possibility.
so like there, if you put the facts all together.
Well, I think if we put all the facts together, we're, at 1:30 at night, it's a small point, but I think it's a relevant point. In D-Ray, the court kind of scoffed at the notion that three people would head and all three people would be Confederates if they headed to a public street in broad daylight and engage in criminal activity. Well, here we're talking about 1:30 at night. We also had the men coming together towards the car, suggesting, again, from a common sense perspective, that they came together in the car, they're leaving in the car. I don't disagree with the notion that we don't know. He didn't sit in the passenger seat. I'm not going to fault for the officers for stopping them at that point. There are three guns at that point they knew in the car. I'm sorry.
No, I think there's no question they had, I think they had reasonable articulable suspicion to stop them.
Mm-hmm. But I think, on these facts, I think we have probable cause given what from the government's perspective amounts to a significant body of pretty incriminating material in the
Sorry. continue.
pretty incriminating material in the car. Ghost gun, 3 extended magazines, 3 firearms spread throughout. The safety concerns, I think coupled, no one's licensed or registered. I think in that context, when you're asking, was there a reasonable belief of guilt? It's not the bomb for sure, but it's down the spectrum, and I don't think it's malt liquor or even the exchange. The other thing, D-Ray scoffed at the notion that gas rations. You couldn't tell gas rations were obviously illegal just from the exchange of paper, and we're farther away from fireworks, malt liquor, and passage of papers when you're talking about the 3 guns here, including one that, I know there was some discussion about the plain visibility of that map pocket gun. Court can look at the photos as well as I can. The trial court made a finding here that it was plainly visible. I look at that.
Based on really nothing. I mean, there's just nothing in the record. We have no idea which way he was coming. If he had been coming from the hood of the car and, we have no idea. But put that aside. My last question is, the government doesn't prosecute him for guns.
Right. And we have.
So what do we take away? If this is like such a strong probable cause case, like, I guess we take away that the government thought, okay, strong probable cause, but no way can we prove beyond a reasonable doubt. Is that?
I don't think we have to take away from that. The record doesn't speak to it, but we test for DNA on guns all the time. And a lot of juries like that DNA. If it's not there, then it's a very easy acquittal, in my experience, and from the records I've read. But Judge Hertzfeld was candid about this. I don't think we have beyond a reasonable doubt here, but I think we have probable cause, and the standard of probable cause, I think, is met here. Unless the court has any further questions, I see my time's up. I would ask that the court affirm this recommendation. Thank you.
Thank you. Ms. McDonald, we'll give you 3 minutes on rebuttal.
Be brief. So I think the government and I agree here that a common enterprise is a way to establish a constructive possession inference. And here, common enterprise is the only vehicle that the government tries to get to a constructive possession inference. And it's weak here when the government talks about fireworks as sort of less obviously criminal. I think it's telling what the court says in TH about the inapplicability in this context of the presumption that people know the law and how some fireworks are legal, some are not. That's true as well of guns. And when it comes to the safety concerns, I think even in the time since Connolly, just recently in Haddix, this court sort of addressed the notion of how sort of obviously criminal, per se dangerous, even an unregistered gun is, and rejected that notion in a world where people have a right to lawfully possess guns for self-defense. And so the common enterprise inference here, to the extent it even applies to possession of contraband, especially contraband like guns, that I think significantly less so than fireworks, doesn't really indicate group activity, just is not a reasonable inference on these.
Can I ask you a question? At the beginning of your argument, your opening argument, you said that your client hadn't even gotten in the car yet. And can you talk a little more about why that fact matters in your analysis? And do you dispute that the driver made some kind of decision to let your client into the car?
I think we don't dispute that the officers could think that the driver was willing to let Mr. Johnson into the car. But the reason that Mr. Johnson hadn't been in the car, that there's no indication he'd been in the car before, I think that's why the government has to filter everything through these inferences about the driver's willingness. And given guns as the contraband, I think the driver's willingness, people possess guns even unlawfully in the presence of other people all the time. I think it's not the kind of activity that people are so worried about witnesses or talebearers that it raises this kind of inference. And so
What about drugs? What about cocaine? I mean, you can go to a nightclub and watch people do cocaine if you want to. People are not so concerned about that either, yet Pringle said that's enough for probable cause.
Pringle said that the indicia of drug dealing was enough for probable cause, and courts have found that when it comes to possession of drugs like cocaine, that's different unless there are indicia of mutual use and enjoyment. So we've cited Virginia cases that say possession of drugs is of a different kind than drug dealing. And I think similarly in TH, the court said if there was indicia of an illicit market in fireworks, this might be a different case. But that I think simple possession matters here, and the government's attempt to argue that there was a common enterprise to possess guns must fail, and we would ask this court to reverse.
Can I ask just one more question
Yes.
about, you point out that guns are not obviously illegal. And I'm not sure that just by looking at these extended clips, I mean, like I said, I think they are rather extended. They appear to me to be 30-round clips at first blush, but they're big. They're more than double the size of the handle of these semi-automatic weapons. But let me grant you, let's just say, okay, it's not obvious that other people are going to know that that's an illegal firearm. Or it might not be a fair inference that Mr. Johnson would have understood them to be an illegal firearm. But because but you would agree that somebody in this car knows that these 3 guns are in there. Maybe the driver, maybe the passenger, somebody knows they're there. Why isn't the relevant question, would they naturally be worried about people coming into their car knowing that they have highly illegal weapons? Highly illegal, more similar to 5 baggies of cocaine than an open container of alcohol. Maybe there might not be obviously illegal, but the consequences are as severe if you get ratted out as in the cocaine instance in Pringle. Not at all similar to if you get ratted out about a polka or fireworks, and also who would do that? Why isn't it just closer to the drugs? That sort of inference that the driver wouldn't let him in.
Yeah, so even in the case of obviously illegal contraband, that doesn't resolve the question. And that's a case like Perkins, right, where it's obviously illegal. And
No, remember, I'm trying
Yeah.
to distinguish between something being obviously illegal and relatively, something in my view can be both obviously illegal and relatively innocuous. A slight illegality, open container of alcohol is that. Something can be less obviously illegal, but the consequences of it being illegal are enormous. You know, a bomb that is hid in a briefcase or an extended magazine in a gun. Those are not 180-day offenses. Those are, I assume, I don't remember, 10-year offenses for the extended clips, 10 years apiece. So the consequences are enormous. Somebody in that car knows that they have these enormously illegal firearms on them. So the inference is a lot stronger than polka, and it's a lot stronger than illegal fireworks. It is possibly more strong than 3 small bags of cocaine. I would think so. So I guess my question is, when you look at it, what's wrong with looking at it that way? And if I look at it that way, do you disagree that this is more like cocaine than an open container of alcohol?
I think it matters, like the inference doesn't just have to be the driver wouldn't let Mr. Johnson in unless he were okay with it, unless he were aware of it, but unless he were actually jointly possessing it. And I think that's where this Pringle inference falls apart, that when it comes to drug dealing, if you're letting in someone who's participating in that enterprise, the inference that you're all possessing the drugs, which it's 5 separately packaged baggies of drugs and a large amount of money, makes sense as possession. But I think it's perfectly reasonable for the driver to think either someone getting into the car for a short distance isn't even going to be aware of these guns, or for the driver to think they're not going to know how obviously illegal there are. And then I think drugs guns aren't the kind of, possessing guns isn't the kind of thing where we're so worried, where a driver, a possessor would be so worried about witnesses. And again, it's not enough for the court to think that the driver wouldn't have let him in unless he were okay with it. It's the driver wouldn't have let him in unless he were possessing the guns as this joint enterprise, is the government's argument. We ask this court to reverse. Thank you.
Thank you very much. And thanks to both sides for your briefing and your arguments today. The case will be submitted. Second case on this morning's calendar is number 24 VG 700. In re Joseph Owens, bar registration number 980-884, or docket number 21 BD 58. Whenever you're ready, counsel.
Thank you, Your Honor. Good morning. May it please the court.
Morning.
My name is William Brennan. I'll be arguing on behalf of the respondent, Joseph Owens, accompanied by my law partner, Mr. Lawler. I think I've asked for 12 minutes for opening. I reserve 3 minutes for rebuttal. During that time, I'd like to cover 4 major areas. One is whether or not this court in the first instance should have dealt with this, or should be the proper form to deal initially with this case, in as much as we think it's solely a Maryland case. That's number one. Number two, we'd like to talk about the choice of law issue in this case, because both the board and the hearing committee applied Virginia law when we think nothing occurred in Virginia. 3, briefly like to discuss the fee agreement and whether or not there was any misappropriation. And finally, I'd like to talk about the sanction. We think the sanction recommended by both the hearing committee and the board is unduly harsh under these facts. But I think we start with this proposition, if I could say. Both the hearing committee found and the board found that nothing occurred in the District of Columbia.
Counsel, I just find this argument, it seems to reveal just a fundamental misunderstanding of our licensure process, right? The issue is whether or not your client should have a bar license in DC, right?
Right.
The misconduct could happen on the moon, but the question is whether or not the attorney who is licensed in DC gets to retain their ability to practice here.
Right.
And we have an essential interest in determining whether someone should continue to have a license to practice here. And the fact that nothing happened here is completely immaterial.
Well,
It reflects on whether or not we think this person should have a license here.
and clearly I agree with that. And in reciprocity cases, this court.
It's not just about reciprocity,
But
right? Reciprocity is one way that we deal with the licensure. But maybe all the other 49 states are sitting on their hands. Maybe they're overworked and they just don't have time to investigate this. Maybe the person came to us first and said, this misconduct happened.
Right.
It doesn't matter.
Well, I
We
think
get
though,
to decide who gets to be licensed here, and we have an essential interest in that.
I don't disagree with that, but the point I would like to make, and I think this is important, if the lawyer is operating under what he or she believes to be the rules of the jurisdiction in which they are admitted, and the lawyer in good faith believes they have complied with those rules, and that jurisdiction has just taken no action or has taken minimal action, then I think this court should give great deference to the state of mind of a lawyer.
Why? It's about whether or not they get to be licensed here.
Right. But what I'm saying, Your Honor, is that what happened here in the.
And I thought your argument was actually jurisdictional. And I thought you were saying that we didn't have jurisdiction to decide who gets to have a license here. And quite frankly, like I said, I think that that reveals just a fundamental
No.
misunderstanding of the licensure process.
No, I agree. This court has jurisdiction to control the lawyers that appear before it, without a
Right,
doubt.
so you just want us to defer to other jurisdictions, and why would we do that?
Well,
If we don't think that the other jurisdictions are taking certain types of misconduct seriously enough,
Well,
if right, I mean, there are myriad reasons why we would not do that.
well, Your Honor, I would.
And that
repeat what-
just has not been the rule. Do you have cases to say that that's the rule?
Well, what I would say is that if a lawyer is operating, let's say we're in Maryland, let's say where it's like the middle of the country, say Indiana, and a lawyer is practicing in Indiana, all the conduct occurs in the state of Indiana. The lawyer, in good faith, complied with the rules of the state of
These are
Indiana.
all arguments that can be made to our hearing committee if we bring charges against the lawyer.
Right.
We'll entertain those arguments. That's fine. But it does not mean that we don't get to hear the case.
Clearly, at some point, I think this court should hear the case. If Maryland had taken action, if Maryland said, this is,
Isn't there now action in Maryland related to these matters?
and has been deferred pending resolution of this court. And
But,
on the
I
rest,
mean, Maryland can choose to do what it wants to do, but to say, I don't know what happened in Maryland and why they didn't take action initially. But we took action and there was investigation and then there was a hearing and evidence was developed and findings were made.
So-
I don't quite understand what the argument is.
well, I won't belabor the point. I understand your Honor's point. My point is that the matter should, in my opinion, you should be defer the matter back to the state of Maryland and get it more clear and
Why do we
concise,
defer back to Maryland when we've done all the work?
because it's a Maryland case.
That
And-
impacts whether or not someone gets to have a license in DC.
All right.
We're not deciding whether or not they get to have a license in Maryland or Indiana or anywhere else in the United States. It's only whether they have the privilege of practicing law here. And that is uniquely our determination. And I just don't understand the.
I will move on, having heard your Honor's opinion, I will move on to number 2, Your Honor, which is a choice of law. And at one point, both the hearing committee and the board said that Virginia law should apply in this case. And nothing occurred in any tribunal in the state of Virginia in this matter. Had the hearing gone forward, it could have occurred at one of 3 locations, the location of where Mr. Owens' client resided, which was New York, the location where my client has his office, which is Maryland, or where the Pentagon is located, which is Virginia. None of that occurred, and yet the hearing committee and the board applied Virginia law in this case for making a determination whether or not my client had violated the rules of professional conduct.
They also went on to analyze the violations under Maryland and DC law and under our ethical rules and said, and it doesn't matter anyway. Any way you slice it, we have an intentional misappropriation here, the result would be the same. So what's wrong with that? I mean,
Well-
I suppose my question is, why do we care about this choice of law question?
Well, I think we care because under both the hearing committee and the board said it's likely what Maryland would have done, yet they didn't really rely on any of the pertinent current Maryland cases, and they made a determination, unlike a reciprocity case where there would be a court opinion clearly delineating what Maryland had done. In this particular case, the hearing committee and the board said it's likely Maryland would do this, but not definitive.
What do you mean when you say do this? We wouldn't defer to what Maryland would do as a matter of sanction. If we applied Maryland's rules and intentional misappropriation is a violation of Maryland's rules, is a violation of Virginia rules, is a violation of DC rules, then we would exercise our own judgment about what that ethical lapse, whether under any one of those, not with any difference to what we would predict Maryland would do. We would say, and in our rule, in our jurisdiction, intentional misappropriation gets you disbarred. Absent, one or two cases with really extraordinary circumstances that aren't going to help you out here. So again, do you agree that intentional misappropriation would be a violation of the rules of all three of those jurisdictions?
I agree that intentional willful misappropriation of funds would result in a severe sanction in Maryland, Virginia, and the District of Columbia, without a doubt. However, going part 3 of this, I don't think the record in this case supports a willful intentional misappropriation in this particular case. And here's why. The client in this case, not Mr. Owens, but his client, insisted that this flat fee agreement have an out clause. If it was terminated for any reason, it would be billed out at $250 per hour. It was a $4,000 flat fee. Upon the completion of 16 hours of work, Mr. Owens would have earned that fee. Now,
No.
I agree.
No,
that
I'm sorry.
I-
No, that's not what the agreement was. The agreement was not, I do so many hours of work and I have earned the flat fee. The flat fee was for the entirety of the work.
don't disagree.
And if the work, the relationship were terminated, then you would calculate hours. But your client withdrew the flat fee when the relationship had not been terminated and the entirety of the work had not been done. That was not the agreement.
I agree that my client was obligated under that agreement to complete the representation through the hearing. Don't disagree with your honor on
No,
that.
it's not just that he was obligated to complete the representation. He was not allowed to withdraw the flat fee at that juncture.
And that, your honor, then gets to whether or not that was a willful misappropriation or an negligent misreading of the rules in terms of he believed. I mean, I think this is very important. My client believed under the clear terms of that agreement, once he'd completed 16 hours of work, the fee was earned.
That's
Now,
just not what the agreement says. So it seems quite unreasonable for him to have thought that.
so the question then
I
becomes
mean,
is,
he is a lawyer, right?
he is a lawyer.
He negotiated this agreement with
He-
his client,
he-
and it seems pretty clear what the agreement says.
Right. So the question then becomes is under Crane, which is a lead case in this court, is whether or not that withdrawal requires any culpability or does not require any willful culpability. Is it a per se offense or does it require some culpability? And our point there, your honors, is that once the hearing committee found and the board adopted, they found that disciplinary counsel had failed to prove by clear and convincing evidence that the fee was unearned. And they made a finding of fact to that effect, they made a conclusion of law that disciplinary counsel failed to prove by clear and convincing evidence the fees were unearned. Now,
At a later point in time, though. Yeah, once the termination happens,
sorry,
that at a later point in time, once the termination of the agreement happens, then it says, we don't actually believe your client that he did the work. But he hasn't turned over his records. He's got nothing in terms of a paper trail. So we're at a little bit of a loss here. So we're not going to find by clear and convincing evidence that he didn't earn the fee. But that's very clear. They find he hadn't earned the fee at the time he withdrew it.
Well, I'm not sure that follows. I mean, I think if they're saying that we can't, they did not prove by clear and convincing evidence the fees are unearned.
But the timing is everything under the agreement, right? Because the timing is, look, if there is a termination, then we can look to hours worked.
Right.
But if there hasn't been a termination, as there was not in this case, then this is a flat fee. And to your point that it was reasonable for your client to interpret this agreement as essentially imposing an hourly rate system, your client didn't even keep his hours. So just as a factual matter, it seems unsupported that that's how he interpreted this agreement.
Right. What the point then becomes is if he had in fact done the work.
No. But you were making a mens rea argument of he reasonably believed this to be an agreement that allowed him essentially to charge an hourly rate.
Because
But my question is what facts support that? If in fact your client didn't actually keep hours,
because once you,
as Judge Deal noted, he produced no records.
Right.
Right, he didn't, and he admitted, I don't even know how to keep hours. So and please explain to me, how is it that the facts support that he reasonably understood this flat fee agreement to be an hourly fee
I
agreement?
think my client believed at the time the monies were transferred from the Ulta account to the operating account by his law partner, made that transfer. The client believed that because he had done the work in his mind, because he had done the
But
work for
what-
16 hours.
What documentation did he have to show that he had done the work?
He
As far
testified,
as I'm aware, the record contains none.
well, he doesn't have any documents, he didn't keep any timesheets. Testified that in his mind, he had done the work. And at that point, he knew that he would not have to refund any money. That's it. And I think that,
He's not credited on that point, though.
I'm sorry.
He is not credited by the hearing committee on that point. The
Oh.
hearing committee says, we find him non-credible in saying that he had done 16 hours of work.
Well, they also found that that bar counsel or disciplinary counsel, excuse me, had not proven by clear and convincing evidence that his client was entitled to any refund.
Yeah, sure.
And so I think that under Alexi, which is interestingly was decided the same day, the board report came out in this case by this court that basically says that Mance is shall be prospective only. And Mance has been the jurisdictional milestone in this court for a long time. The Alexi case decided on August 1st of last year, the very day we got the board report in this case, said that Mance is in fact the rule. It is strict, but based on Alexi is to be applied prospectively. So we think that the sanction of disbarment in this case, in light of what this court held on in Alexi, is not warranted. And so we'd ask that this court not disbar Mr. Owens, but then for it, in fact, impose something less than disbarment, but a suspension based on all the facts of this case. And I see my time's up. Any further questions? I'll sit.
Thank you, Mr. Brennan, and we will give you a couple minutes on rebuttal. We will hear from disciplinary counsel.
May it please the court, Jack Metzler for the Office of Disciplinary Counsel. I'm a little bit at a loss because the court has done a better job than I would of making the arguments that I wanted to make. But I will add just a couple of things. First, with regard to the purported good faith belief that Mr. Owens, that my friend says Mr. Owens had when he took his client's fee and paid his credit card bill with it. The hearing committee found that, the idea that he was allowed to take the money after working 16 hours was made up, and he was intentionally lying about that. It's not that he didn't have a good faith belief. It wouldn't be reasonable for him to believe that the contract required it, as the court said, but he didn't actually believe it, and that finding is covered by the Crane case, which talks about the deference that is owed to hearing committee determinations about credibility. And in this case, what happened was Mr. Owens testified at length in the fee dispute litigation about about his understanding of the contract. And he said, look, it's a flat fee. I don't do hourly. If it was an hourly case, I wouldn't have taken it. I don't, he takes some cases. The hearing committee held this from Maryland because where Maryland would require him to report his hours and he could get paid for it, but he doesn't do that because he doesn't like doing hourly billing so much that he does those cases for free. So his testimony was false, and he didn't believe it either reasonably or otherwise. With regard to the Mance case and the Alexi case, I just wanted to have one note about that. First of all, those cases involve DC law, so not Virginia or Maryland. And the nuance that the Alexi case added involved a lawyer who took part of a flat fee in the course of a representation. And so the question was, where there was nothing in the fee agreement that said he was allowed to do it, could he take part of the fee doing part of the work based on his representation that he had earned it? This case is entirely different because Mr. Owens took all of the fee. He took the entire $4,000 that was supposed to pay for the entire proceeding all the way through the hearing. And there's no question that he couldn't have earned the whole fee because he didn't do all of the work.
That's a pretty thin distinction, though. I mean, if he had left $1 in that IOLTA account, you could say that's good, and that's the remainder. And then Alexi might apply to say, we could only disbar him if it had post-dated Alexi.
Well, our argument is that was well established before, but the court chose in the Alexi case to make it prospective. And I think we would have I'm sure I would have something to say about a case where there was $1 left in the account. But there's no question here. And in fact, Mr. Owens admitted this when he testified here in support of his lie about believing that he could earn the fee hourly. He said, look, if this was a flat fee, I wasn't allowed to take the whole thing. And that's at finding of fact 59.
Can you reconcile for me the findings, if I have this right, of the hearing committee, that he's not credible when he says he believed he had done the work, but they can't find by clear and convincing evidence that he took an unearned fee? Is it that the lack of credibility just isn't enough to get you to clear and convincing evidence, but it could be a piece of proof to, as relevant to a different charge? I mean, those two things seem a little bit tough to reconcile to me, and I'm just not sure.
Sure, and I agree with you. It's and the discussion, the hearing committee's discussion on that point is not entirely clear or very detailed. But the one correction to the question, what the hearing committee found was that we hadn't proved by clear and convincing evidence that Mr. Owens, the amount that Mr. Owens failed to refund was unearned. And the hearing committee wasn't clear what it meant by that, because the facts were initially the client asked for the entire $4,000 back. Mr. Owens said no. 3 months later, he gave him back $2,000, and the client went to the arbitration board and then ultimately went to enforce the arbitration award in court. And the result of all of that was all of those bodies held that Mr. Owens could show he worked at most 1 hour and earned $250. So in the face of those facts, I don't know what the hearing committee was thinking. Did it think that there wasn't clear and convincing proof that he hadn't earned maybe $2,000 when he refunded the $2,000? I don't think it said, or I don't think it's a reasonable interpretation that it thought that there was any possibility he had earned the entire thing, because earlier in the opinion, the hearing committee says, well, he clearly didn't earn the entire thing because he didn't finish the job. I guess.
Well, that's not quite right, though, because at termination, he could have earned the 16 hours worth.
Yes, exactly right. So, I guess what you could say is the hearing committee thought, well, it's, possible that he worked and just didn't track. He did work 16 hours and he can't explain it to us, but disciplinary counsel has a, you know, and they said this, an impossible task of proving a negative, proving that he didn't actually work on the matter, even if he's unable to explain it in a satisfactory manner or a credible manner. So, you know, if that had been the case, if that had been the charge in the case, we would have taken exception on it. But, you know, that wasn't the only charge in the case. And so we elected not to. But I think the reconciliation is that is the difference between proving the negative that maybe it possibly happened that he had worked and just can't articulate it in any way, versus the finding that he definitely did not earn the money when he took it, when he used it to pay off his credit card bill, because at that point the engagement was ongoing and he could earn it only by completing the engagement, which he had not done. No question about that. If there are no further questions, we ask the court adopt the findings and conclusions of the board and order that Mr. Owens be disbarred.
Thank you. Mr. Brennan, we'll give you 2 minutes on rebuttal.
Thank you. So with respect to Alexi and the sanction, I mean, I think Alexi is clear that the Mance rule, which had been out there for a number of years and followed up by Pons, made it clear that Alexi now was saying that the Mance rule is prospective only, that it's going to be strictly enforced, and that that's what this court should guide itself by. And so I think the important thing is that when the hearing committee below found that disciplinary counsel not proven by clear and convincing evidence that the fees are unearned, that finding of fact is there, that conclusion of law is there. And I think that it's clear that in terms of it becomes then an earned fee, but maybe an unauthorized transfer. And the question left open in Crane, and it's a direct issue with Crane, is whether or
I'm
not.
sorry, just getting a little bit confused because it sounds to me like you're flipping back and forth between the merits discussion and the sanctions discussion,
Right.
right? And so for the merits discussion, we're not applying DC law, we're not applying Mance. That's correct?
That's correct.
So how is it that sort of Mance comes into the picture then for sanctions?
Well, I think that the jurisprudence of this court is that the sanction is determined by the jurisprudence of this court.
Yes, but
And
if
so-
the merits, I mean, Mance is setting a merits rule about how to deal with flat fees. We're not applying the merits rule of Mance in this case.
but
So I'm just not, it's not clear to me how that affects our sanctions calculus, if you could explain
Well,
it to me.
I will, Your Honor. So what we're saying is that when a disciplinary counsel mentioned that, or someone mentioned that the Maryland jurisprudence had found that the fees are unearned. But that standard in litigation in Howard County was by a preponderance of the evidence, was required to be proven for the hearing board, for the hearing committee, before the board, and before this court is clear and convincing evidence. Clear and convincing evidence, there's a finding that unable to prove that the fees are unearned. So I think what I'm saying is in terms of the sanction that should be imposed, look at Crane, and Crane says, leaves open the question whether or not culpability is a factor in this matter. And I would say that it's not a per se offense, that you should look to the entire facts of the case, look at what occurred in this case, look how it occurred, why it occurred. It's an unusual case in the sense that the client, and I won't belabor the point, I know what the Honor's point is, but I think in terms of sanctions, disbarment is not warranted in light of all the factors in this case. Thank you.
Thank you, Mr. Brennan and Mr. Metzler. The case will be submitted. The third and final case on our calendar this morning is in re estate of Ramon Osuna, Julie Lennon appellant, numbers 24 PR 332 and 24 PR 592.
Good morning, Your Honors. My name is James Sherry, and I represent Julie Lennon as the executrix of the estate of her late father, Robert L. Lennon Sr. Ramon OSUNA,
Pull your, the microphone over
sorry.
a little bit more. Thank you.
is that clear? Ramon OSUNA died testate on April 30th, 2020. He left behind a business, a collection of art and antiques, and a loving life partner of 50 years, Mr. Robert Lennon. Mr. OSUNA made provision for his partner by making Mr. Lennon the sole residual beneficiary of his estate. And the probate court correctly recognized that, quote, Mr. OSUNA intended generally for his estate's property to go to Mr. Lennon as a fallback by the way of the residuary clause in Mr. OSUNA's will. But the probate court misconstrued the plain language of two specific bequests in the will. In both cases, the probate court construed the will as conveying Mr. OSUNA's entire fractional interest in two works of art, when by the plain language of the will, Mr. OSUNA conveyed only half of his own fractional interest in those works of art. That interpretation was wrong as a matter of the plain text of the will and should be reversed on de novo review. That interpretation also had the practical effect of disinheriting Mr. OSUNA's partner of 50 years and leaving the estate unable to satisfy several large cash bequests that he added in the last weeks of his life. I'd like to begin.
That part of your argument is based on other evidence, is that right?
That part is based on extrinsic evidence, Your Honor, and I wanted to start with the text of the will itself, because we are absolutely not taking the position that these bequests are ambiguous or that reference to extrinsic evidence is necessary. However, the probate court seemed to think that it was, although it didn't expressly characterize the will as ambiguous in these two provisions. It did characterize the parties' opposite interpretations as both being reasonable. So ambiguity is in the eye of the beholder. And so our first line position is that these are not ambiguous bequests. They clearly convey only half of the interest. If reference to extrinsic evidence is made, however, to resolve an ambiguity, it confirms the correctness of Mr. OSUNA's interpretation. I'd like to begin with the Poussin bequest and the plain language of the Poussin bequest. The painting in question is Rest on the Flight into Egypt by the French Baroque painter Nicolas Poussin. Mr. OSUNA owned a 50% interest in that painting. The other 50% was owned by Perry Rush Lennon, not Robert Lennon, but Mr. Lennon's son, and is now owned by his estate. That bequest reads in full, of my estate's share in the sale of the painting of Nicolas Poussin, Rest on the Flight into Egypt with St. John the Baptist, when it sells, I give, devise, and bequeath to Lorenzo Pericolo 40% of our interest and to Scott Schweigert 10%. The probate court construed that provision as conveying Mr. OSUNA's entire share of the Poussin to the named legatees, leaving the residuary estate with nothing. But the provision can only be read as conveying 50% of Mr. OSUNA's own interest.
Do you see the Poussin bequest as being a stronger language than the Titian bequest?
Your Honor, I think that those two bequests, the differences between the language is subtle enough that it strains credulity to think that Mr. OSUNA would have intended opposite outcomes by the rather subtle differences in the language between those two bequests, given their parallel structure. But I do, yes. I think that the Poussin bequest is slightly clearer on this subject because when it gets to the fractional interests, he repeats the point, 40% of our interest.
Well, just to pause there, because then when you described what that meant, you said what he meant was of his own interest.
Correct.
So the pronoun, if that were right, would be my. So why is it our?
So the pronoun, I think there's three possible things
Uh-huh.
he could use, he could mean by our, correct?
Right, your
First, he could
brief
mean-
stuck to him, he meant the estate, and that would still
Yeah.
be a weird pronoun.
First, he could mean my, a sort of royal we,
Uh-huh,
right? Which is the first word that he uses in the very same bequest, of my estate's share. And then he continues 40% of our interests here and there. He could conceivably mean mine and Perry Rush Lennon's, but I submit that's a bizarre construction given that he is writing his will in a way which gives away property that doesn't belong to him.
right,
In that phraseology. I think he might also have meant himself and Mr. Robert Lennon,
right.
as they were a couple at the time of his death.
I think
don't-
I think that one's it. I think
don't
that's what he
think-
means.
Yeah, I think it probably does too, or it's a royal we. I don't think any of those constructions, though, supports the probate court's conclusion that he was conveying all of his own interests, right? I mean, the first words are of my estate's share, and when he gets to the fractional interest, he says 40% of our interest. The probate court took that to mean 40% of the total sales proceeds of a painting of which Mr. Osuna owned only half. And to reach that conclusion had to engage in a quite blunt rewriting of the language of that clause. If you read the trial court's order, when it actually breaks out the percentage, instead of conveying 40% of the estate share as the will states to Mr. Pericolo, it says ordered, paragraph F of the addendum bequeaths 80% of the estate's share of the Poussin sale. And instead of conveying 10% of the estate's share to Mr. Schweigert, as the will states, it reads, quote, ordered paragraph F of the addendum bequeaths 20%. It's a
Maybe-
straightforward doubling.
Yes, it is. But maybe the trial court went in that direction because of the way that the petition provision is written. And, you know, we generally read things in order, and you've gone straight to the Poussin, but petition comes first.
I went to the Poussin because I think it is clearer and no one has appeared in the appeal to defend the
Right, but you
Poussin.
know, if, I
Yes.
mean, he wrote it in order, and petition is C and Poussin is F, and so, you know, the petition talks about the percentage of the sale proceeds, so it gets a little.
Let me address that, Your Honor.
muddled.
If you read the petition, if you
And he doesn't
ellipsis,
possess, to your point, he's not entitled to the entirety of the sale proceeds.
correct.
So
Absolutely
It's a
correct.
little odd that it's in the addendum.
Well, let me turn to the language of the petition request if I can, because I think if you just ellipsis out the very long name of the painting, it's quite clearly a reference to the estate's share of the sales proceeds. It would read, of my estate's share in the proceeds of the sale of the Titian to Robert Thano, 25% of the sales proceeds, and to Jack and Anna Rasmussen, 25% of the sale proceeds. Once again, the court and the Rasmussens argue that that means total sales proceeds. But the sentence begins, and again, if you just cut out the kind of fat middle, it's quite clearly a reference back to the estate's share of the sales proceeds that begins the same request. So, Your Honors, these are the plain text arguments based on just the language of the Titian and the Poussin bequests themselves that we think decide this case and decide the case without the need for reference to any extrinsic evidence. If we turn, excuse me, to some other language in the will and probate, so again, not looking to extrinsic evidence yet, but just comparing to some other language in the will, I think there are some provisions that confirm the correctness of Mr. Lennon's reading of the will. First, paragraph E of that specific addendum is the bequest to Mr. Pazzo de Zayas, which says 150,000 and all my interest in the art in a gallery in Peyton Wright, Santa Fe. When Mr. Osuna wanted to convey his complete interest in a work or works of art, he said, all my interest. When he wanted to convey fractional shares of his interest, that's what he did.
But that, I mean, I guess that's not quite true, because in the preceding paragraph D, he bequeaths to Dr. Gutierrez 37.5% of the proceeds, and he only has a 37.5% interest, right?
Correct, Your
So,
Honor. And that
so he
was-
doesn't always say all my interest when he means all my interest, is my modest point.
Not always.
Okay.
But he does in paragraph E, and in paragraph D, what he does not say is of my estate's share. In paragraph D, he happened to own a 37.5% share of the Rosa painting. He gifted that entire share to Dr. Guillermo Gutierrez, and it does not include the prefatory language that begins paragraph C and F of my
But
estate's
one thing
share.
about your argument on that confused me, and maybe you can explain. As to the Rosa bequest, you say, you know, the 37.5% of the proceeds when it sells clearly reflects his intent to convey, you know, the entire interest in this item. because it didn't use the limiting language that we see in the Titian and the Poussin bequests, at the beginning, the of my estate's share. But then you also argue that if we removed that opening phrase from the Titian bequest, that the bequest would then be ambiguous.
I think it would.
Okay,
Your
leaving
Honor, I
on,
agree.
you know, because we wouldn't know what sales proceeds meant, but doesn't that look a lot like the Rosa bequest at that point that you say is so clear?
Your Honor, we have not challenged the Rosa bequest, and we haven't tried to argue that any balance of the Rosa bequest reverts to the estate.
But you do use it as an example for it when he says he wants to give his entire interest away, this is how he does it, and it's clear. You know, I'm only asking, is there tension between your saying that and your saying, if we hypothetically take out the beginning of the Titian request, that it would be ambiguous, because it
I don't
seems like it
think,
would be.
I don't think so, Your Honor. It's a difference in the phraseology between the two requests that I think makes an important difference. And I do think the Titian bequest, because it's a little closer, because the fractions refer to fractions of the sales proceeds, that bequest might actually be ambiguous if it didn't begin with the phrase of my estate's share. But as I was just reading to the court, if you collapse that sentence, it's quite clear that those fractional percentages of those sales proceeds refer to that first phrase in the bequest of my estate's share of the sales proceeds from that painting.
Do you think that there should be just kind of a general presumption that the decedent testator is only giving away what he actually owns? I mean, I guess it just seems like it would be an odd thing to say, I only own 50% of this painting, but I'm giving someone 25% of the sales proceeds. Because who knows, you know, something might happen with the sale, right? That then, you know, some third party might have some sort of lien, or I don't know. There might be some sort of complicating factor that means that 25% of the sales proceeds is not actually the net that is left over from the sale to be distributed.
So
Am I
I
making any
I may not
sense?
understand your Honor's question exactly right, but I think I do.
Sort of tied to this language that's in the various provisions generally, but I'm just wondering if there should be kind of a general presumption as we're reading the addendum that the testator is only giving away what they actually own.
So I think this is rather close to the question Judge Deal had about our. I think there should be a presumption, or at least it is an unnatural reading of our, to think that he's also, Mr. OSUNA is also referring to interest in the painting that he does not own. That would be a strange way to structure a gift and a will. I think, though, that this may be what Your Honor is asking. I think that the genius, if you will, of the structure of the Titian and Poussin bequests, keep in mind that Mr. OSUNA owned fractional interests in many works of art, and he was an active art dealer whose own percentage ownership often changed, right? The way the Titian and Poussin bequests are structured as we read them, they would remain effective if Mr. OSUNA were to dispose of a further percentage of his ownership during his life, but before his death, right? So if he had, for example, sold half of his 50% interest, reducing it to a quarter, these bequests would fail, right? Because if it's a total sales proceeds, he no longer has that much. But if it means what we say it means, and he's giving a fraction of his own interest, whatever that is, those bequests will remain effective even if his percentage ownership changes before death. To turn briefly to the issue of extrinsic evidence, if the bequests are regarded as ambiguous and extrinsic evidence is looked at, there are several pieces that I think are key to understanding it. First is a drafting history of the will and the revisions to the will between 2018 and the will in probate. And I think the single clearest and most important point here is the change in the Poussin and the gift to Scott Schweigert. The 2018 will cannot reasonably be read as conveying to Mr. Schweigert anything other than 10%. And I'd submit it's just implausible that by the language changes in the 2019 will, Mr. OSUNA intended to double that gift. More importantly, I think the probate court was entertaining an idea that it was just implausible or unlikely that Mr. Osuna would have intended any fraction of the Titian and Poussin gifts to revert to the residuary estate. But you can't read the 2018 will any other way. He was only giving away 10% of a painting of which he owned 50. Even if you doubled that 10 to 20, 80 or 90% of Mr. Osuna's interest is going to the residuary estate. So it's a complete, he could and did intend to structure those gifts in that way. I see I'm out of time, Your Honor, and I did not reserve any, if I may. Reserve two
Yeah,
for
we'll
rebuttal.
certainly give you a couple minutes on rebuttal. Sure.
Thank you, Your Honor.
May it please the court, Stephen Klepper for Jack and Anna Rasmussen. As Mr. Metzger said before, I think the court pretty much covered most of my points already. I will begin with, as they say, they do not contend that this is ambiguous. And under Riggs versus Summerlin, what does that mean? It means that you look at the will's four corners to arrive at the most reasonable and natural construction.
Well, can I interrupt you
Yeah.
and ask, a lot of your argument is looking at every other provision in the will but you don't defend the probate court's construction of the Poussin bequest. Is that correct?
Well, we don't represent them,
Right.
but let me get to that a bit, because that was a significant portion, because what they're trying to do is to say, well, you know when a truck beeps and backs up, they're trying to back into paragraph C from paragraph F, something to turn this into. This was the issue of hour. So when they say there are three different constructions that came up, this was in Judge Deal's questioning. Well, and they concede one of them, this could mean Mr. Lennon and Mr. Osuna and the Lennon family. Because if you look at page 36 of the appendix, and this is also page, I believe, 22 of their brief, what they concede is that, so as to the Poussin, that was the 50% that was owned by Perry Rush Lennon was an inter vivos gift. And if you think of inter vivos gifts and you think about gift tax works, and I remind you, it's been many, many years since I took a state and gift tax, but you need to account for inter vivos gifts as part of doing an estate tax analysis. And so when they talk about R, compare that to paragraph E, because in paragraph E, he says, my interest. So if we're giving every word meaning, my interest in paragraph E has to mean something different from our interest in paragraph F. And what one can reasonably arrive at, given these circumstances we talk about, is that they're talking about the fact that this was already a during their life way of supporting Mr. Lennon's heirs. When you talk about ours,
Can we just talk about the prefatory language in both C and E?
Oh, yeah.
Of my estate's share of the proceeds of the sale of Titian, I devised 25% to Jack and Anna Rasmussen and 25% to Robert Thana. I mean, I agree, that's very clear. I just don't see how it's clear in your favor. It is of Mr. Osuna's share of the proceeds of the sale. 25% to each, the remaining 50% goes back to Mr. Lennon.
All right. Let me begin, Your Honor, with, the of has to be really manifestly modifying 25% of the sale proceeds. Of is doing a lot of work there. Of means a lot of different things if you go to the dictionary. Now, would I have drafted this to begin with the word of? No, but of means a lot of things. One of them is as to, in regard to, concerning. This isn't saying from, or like I have defined the denominator. Now their construction depends on the notion that is so clearly something that is saying, well, I'm only talking about this.
Let's just, okay. As to my estate's share of the proceeds of the sale, I give 25% to Robert Thano and 25% to Jack and Ann Rasmussen. Same thing.
I disagree.
It's still 25% of his share of the proceeds.
I disagree, Your Honor, because it says 25% of the sale proceeds. There was one sale, Your Honor. The sale proceeds.
Right, but you're ignoring the first part.
No, I'm not ignoring the first part, Your Honor. What I'm doing is I'm reading the sentence as a whole.
What do you think the first part means?
I think
it just seems like you have read it out of out of the provision, out of the addendum.
In the two places where it says of my share.
No,
what,
let's
uh,
just stick on addendum
on-
C.
on C.
What does the prefatory language of my estate's share of the proceeds?
What it is meaning is that.
To you, under your interpretation of, well, of means many things.
Okay, turning to the share of the proceeds of the sale. I'm splitting this among two people. That is the
No, it's of
introduction
my estate's share of the proceeds,
of my estate's share of the proceeds.
right?
I interpret this as
My
turning
estate-
to.
My estate only has, a certain part. And then of that share, 25% goes to one person, 25% goes to two other people. That leaves 50%
It says 25% of the sale proceeds, Your Honor.
of my estate. But again, like, I don't understand what you think the prefatory language means.
What I think it means, so
Other than,
I have.
than it has
So
no force
what we
at
have
all.
done, Your Honor, is we've gone through and you have said, all right, so if we're saying that C, it's not clear stating by itself, there's nothing else. What we do
I
then
think
we,
it's plain, and I'm trying to understand what you think the contrary meaning is. You have said of can have many different meanings,
Mm-hmm.
and I am trying to understand what you think of my estate's share of the proceeds of the sale means. And I haven't heard you give it any meaning other than to say we should just read it out of the paragraph.
I think it situates the reader as to what we are talking about to clarify that this is a matter where it is a fractional share. And is being divided among two different people. And if we were to continue to read for
I
context.
just don't understand that. So it's a fractional share. Here's my fraction. Of that fractional share, 25% of it is going to one person, 25% is going to two other people. And, math isn't my strong suit, but 25 and 25 add up to 50 and leaves another 50 left over.
Your Honor, what I will say on that is that would then read this parallel language as 25% of my share of the sale proceeds. I think that to arrive at that clarity. Now, I was starting.
Why is that so wrong? It seems like either you do that, which seems entirely normal and natural, or I still haven't heard what you think that prefatory language means then.
I think that word means that we are situating, this is about the sale proceeds of
Not
my
the
estate share.
sales,
What he
the
is saying is,
estate-
I have a share. I have a share that shares of the proceeds of the sale. I'm entitled to that. Now that we have situated the reader above that, I have only a share of this. What I'm doing is, so my share is
But he
50%.
wouldn't
I'm
be
dividing this
writing
into
this
two.
addendum if he didn't own the property to begin with.
I'm sorry, I
Why
missed
does
that
he have to
question.
situate the reader to tell the reader that he owns this?
Well,
He wouldn't be writing the provision to give it away if he didn't own it.
well, Your Honor, as we go through it, it contains language like Titian's Italian 1485 to 1576 in here. You could identify it without that information in there. And I think that particularly when you've reviewed this, I don't think that the of my estate share is doing that work that you believe that you have expressed it means.
Do you think it just means regarding my estate share?
I think
For
it
the
can mean
proceeds.
regarding, it means as to, it can mean turning to. Of is not a word that has a fixed meaning. And
I use of all the time. I've never been so confused about it as I am right now.
same,
But I mean, it sounds like, but I mean, the best you could hope for right now, because you're saying of can mean from, but doesn't need to here. The best thing you could hope for with this argument, which I don't think you're going to get, is ambiguity. And if you get to ambiguity, all the collateral evidence is against you too.
Well, the collateral evidence, Your Honor, is in the realm of what was deserved by Mr. Lennon.
No, start with the 2018 will. Explain to me how on earth the trial court's ruling here isn't totally, her whole starting premise is in this addendum. He's got to be disposing of the entirety of his interest in each of these pieces of works, including the Poisson, including the Titian. One glaring problem with that was I don't see why that's true. But another glaring problem with that is you have this 2018 will where he's obviously not doing that, where he continues to give just 10% of the Poisson to Schweigert and nothing else, leaving at least, I think, his 40% of the interest to go back through the residuary clause to Mr. Lennon.
Well, the
He wa-
2018 will contain the same language as to the Poussin as 2019. Let me, okay, so if we're going to go for some clarification, Your Honor, as we're, so you need to have multiple constructions that are reasonable to the point that the court is left with true doubt at the end of the day for it to be ambiguous, and that's what they're arguing. What this court does under the decision in Riggs versus Summerlin is you try to come up with the most reasonable, and there's a footnote that's dropped to say, reasonable, what we mean is like, Judge Spotswood Robinson was dissenting and disagreeing as to what it meant, and he was a very reasonable person, Judge Robinson, and saying is we're trying to do our best before we move on to anything extrinsic, and coming up with what more naturally the phrase is what is the most natural and reasonable construction. And in that regard, Your Honor, let's look at, so in paragraph I.
We're in 2019 now.
In 2019, I'm going to 2019
Yep.
because I don't see a difference between 2018 and 2019 on that point that Your
Sure.
Honor raises. So in paragraph I, there is a special carve out for Robert Lennon Sr. Like the fact that he is the residuary legatee doesn't mean that he can't get mentioned on this page. Now, if the specific intent.
I'm sorry, I think I've lost you. So I'm
Okay,
looking at
so paragraph I,
just to be, we're in the 2019 will, paragraph
2019,
I.
paragraph I.
And
What
about
it says,
Ken
the
Carlock?
final sentence is,
Uh-huh.
Robert Lennon Sr. can choose from the contents of the above referenced items any
Got it.
pieces for his new abode.
Right.
So it's not forbidden to refer to Mr. Lennon in the addendum if there's a specific intent to benefit him. And so under their construction,
Right.
what
but
was silently
that-
meant
That
was-
provision is just different in that it gives Madison Kent Carlock all furnishings, right? But then has a little asterisk saying, well, yeah, I'm saying all furnishings, but actually Mr. Lennon can pick what he wants. And essentially it seems like Madison Kent Carlock gets whatever is left after Mr. Lennon. So it's not that the residuary clause wouldn't apply clearly to that because he hasn't given Madison Kent Carlock some sort of percentage, unlike with the paintings, where the residue would go back to the estate. This is just, it's just a different provision.
If the intention was to provide for Mr. Lennon, then what we'd be getting into would be, then why doesn't paragraph C say, of my interest, I give 50% to Mr. Lennon and 25% to each of the others?
Yeah, that could have been clear. I mean, I agree with that.
Well,
I mean, I don't think it's a very strong point that when I was thinking of how could he have said this any clearer? How do you say any more clearly that I just want this to come as my percentage of the estate's proceeds? I said, oh, he could have said, and the remainder to Mr. Lennon. So I agree with that.
So, Your Honor, this gets into like the lawyer thing where we like write out a number and say 300 and then put in parentheses 300. And the problem is that every time lawyers do that, like 1 out of every 10 cases, it turns out that those numbers don't match. The more times that you say it out, the less meaning it becomes, and then there becomes this impulse. We have to give every phrase meaning here, and then, well, we're giving meaning to the dates.
No, stop. I don't know what you're saying. Too many words. Too many words for me. So let me try. I would encourage you to show this clause to 10 non-lawyers, and I'm guessing you're going to get back 10 people saying that means that they get 25% from his share. Because that's just what it says. You have to over lawyer it to think that of doesn't mean of, and maybe of is a prefatory clause that's doing no work. And in fact, what he meant to do was give 50% of his share of the proceeds when he said 25 to each of these two different parties.
So Judge Deal, if I may address that, if you were to hand this will to a non-lawyer who doesn't know what Mr. OSUNA owned and did not own, they would look at paragraph D and say 35% of the proceeds. Well, what happens to the other 62.5%? I guess that's, if I'm only looking at this, I guess the other 62.5% is going to the residuary legatee. And so what we
If
are
they-
doing.
Yeah, if they were under the misimpression that he had 100% of it.
Yeah.
But in fact, he only owns 37.5, and that's why he doesn't say of my estate share of the proceeds. If he had said of my, so tell me this, if he had said of my estate share of the proceeds to Dr. Guillermo Gutierrez, 37.5 said 37.5% of the proceeds of the Salvador Rosa. Do you then I might agree that 37.5 is such an odd number that there would be some, maybe what he really means is the entirety of his estate. But I mean, then I think even that would be a hard argument for you. The whole problem with you and in Part D is they don't use the of my share of the proceeds. So it tells you it's the entire thing.
I think, Your Honor, that what makes it clear is the distinct omission of providing for Mr. Lennon, if that were the express purpose. And so they are making two arguments. One of them is that there was.
Why does he have to do anything more than create the residuary clause in the will?
Because if you're looking to provide for someone, what happens is that these specific bequests go out, and then you just look to whether there's any residue at the end. The residue is residue. It's not a specific bequest. So if his intention had been to specifically provide for Mr. Lennon, it would have included Mr.
So
Lennon.
you're saying if it clearly said, I give 10%, if it had clearly said, I have 50% of a painting, and of that 50%, I am giving 25% to person X. So it made it very clear that it was only half of the 50%, right? Then it would not go to the residuary clause unless Mr. Lennon were specifically named, because residue only applies to residue.
No,
and it can't
it's.
apply to the things that are generally left over.
So I would like to direct the court's attention to a case that takes up 2 pages of our brief and that is not mentioned in their brief at all. And this is the Kaiser versus Brandenburg case.
Well, I just would like an answer to my question.
I must apologize. I
Right?
lost.
I think if it is clear in an addendum provision that an individual, a beneficiary of the addendum, is only getting part of what Mr. Osuna owned, and that there is a part, some fraction that is left over, but Mr. Lennon is not specifically named with respect to that fraction. It doesn't say whatever is left goes to Mr. Lennon. It's just silent, but there's a residuary clause.
There is a residuary.
I understood you to say, wait, unless Mr. Lennon is named, it doesn't go to the residuary clause because the residuary clause is just for residue.
No, well, but the residue, Your Honor, if the intent was to provide for him.
So my question is, you agree that if it is specific that Mr. Osuna is only giving part of what he owns and doesn't specifically say what he wants to happen to the other part, whatever part that is, you agree that goes to the residuary clause?
I believe I
and Mr.
do
Lennon gets it.
agree with that.
So
And
the
where that would
silence-
come from.
The fact that this is silent as far as any parts that go to Mr. Lennon and doesn't specifically say in A through H that whatever is left over goes to Mr. Lennon really is immaterial.
I don't think it's immaterial, Your Honor. What I'm saying is that if the intent was to provide for Mr. Lennon, then you would have sold and the specific bequest, and no matter what the estate's other debts were, that half would have gone to Mr. Lennon.
Sounds like now you're backtracking from your answer to me. You think
Okay.
Mr. Lennon does need to be specific?
Well, I'm saying
to the
to-
remaining part.
I am saying that if the parole intent were to specifically use the proceeds of this particularly valuable asset,
But
to provide for Mr. Lennon.
Again, my question is, you have a provision that is very clear saying Mr. Osuna only has this amount
Mhm.
and he's only giving somebody some fraction of this amount. So there is a fraction left over, but he does not specifically say what happens with that fraction. Mr. Lennon gets it or Mr. Lennon doesn't get it if Mr. Lennon is not specifically mentioned.
Mr. Lennon gets it minus whatever other liabilities of the estate there may
Okay,
be.
but we're not, there's no argument before us today that there's some other encumbrance on the estate that prevents Mr. Lennon from getting his
I,
due
I,
share.
I think
Is
the
there?
points that were rejected on the motion reconsideration is exactly the kind of point that they're
We're
making.
not talking about the motion for reconsideration. I'm just talking about the interpretation of the addendum.
When it comes to interpretation of the addendum, here is my position in close, which is 25% of the sale proceeds. The sale, there was not a sale of the 50% interest. There was 25% of the sale proceeds. That is, and so the sale proceeds are 1.84 million. And you divide and you multiply that by 0.25 and you get $460,000. And that going into this level.
It's that it's from the entirety of the share proceeds, not from his estate share of those proceeds.
If of does that, that assumes that of my estate
Doesn't
share
make
of
any
proceeds
assumption. I
is
just
doing
asked the
that work.
question. Yeah, that's right.
And
When somebody says what if it were from my estate's share of the proceeds? Would you agree that you lose this case?
from would be a closer case. I don't think we would.
Okay.
I don't think we would lose because 25% of the sale proceeds refers to the sale, and there was one sale. There was not a separate
Estate's
auction.
share of the sale proceeds. From my estate's share of the sale proceeds. Sale proceeds later just being a shorthand for my estate's share of the sale proceeds. It's a normal way of talking.
I simply disagree that that would be a shorthand there. And what we at that, I would finally just state very quickly, and I wanted to get to this, which is just the decision in Kaiser versus Brandenburg from 1900 is the one that really gets into much of their argument that they're making is, well, there's not enough residue in here to cover all of the estate's debts, and therefore there must have been a specific intent to leave enough in there to cover these cash bequests. And what Kaiser versus Brandenburg does is it blows that out of the water. What it said, because this happens all the time, that there are cash bequests that can't be met. And what it says is you cannot create ambiguity by pointing to lack of sufficient cash at the time of executing the will or at the time of death.
Yeah, they're not trying to create ambiguity. They're not trying to create ambiguity that way. They say the will is clear.
Yeah, they
Say if you find ambiguity though, well, then here's a couple points. One is he would have left nothing to Mr. Lennon if you read it as the trial court did. And that's a fine point. I mean, that's perfectly good collateral evidence, right?
Yeah.
I mean, you can't create ambiguity with it, but in terms of a decent piece of evidence of what he meant, he probably did not mean to leave his life partner with nothing.
I think that what happens all the time, Your Honor, is that testators overvalue what it is they think they are leaving. That happens all the time. And what the trial court found was that for the paragraph E, that 150,000 and all my interest in the art at Peyton Wright Gallery did not include the matters that were not at that gallery, but that were co-owned with PWG Incorporated. And that was the art that was, that we're talking about like 154 pieces of art that I believe was intended to, I believe that could be read within that world as intending that would be what would be giving Mr. Lennon a residuary share in that. Now, there was a settlement that was reached between, and that's in the record that they designated in there, that is between the estate of Lennon and PWG, and we don't know what the terms of that settlement were. There obviously cannot be in the record, but if that's what we're talking about there, saying it would leave him nothing, well, no, nobody is disputing that that there was about 154 pieces of art, I believe, that I'm sorry, that some portion of the 154 that was not particularly at Santa Fe, that was funding the residue. And if I see no further questions, I would ask that this court affirm.
Thank you, Mr. Klepper. And Mr. Sherry, we will give you a couple minutes on rebuttal.
Your Honor, just very briefly, I do want to make one thing clear. The reservation of half of the sales proceeds of these paintings does not mean that half goes to Mr. Lennon. It means it is retained by the estate, and then it satisfies first expenses of the estate, creditors of the estate, specific cash requests, and then would go, if there were any demonstrative legacies, they'd be next. If there are not, then it goes to the residue, right? So the purpose is, and I know we're getting parole here and we only go here if it's ambiguous, but the purposes of reserving half are multiple. One is to make provision for his life partner of 50 years, but another is to make sure that his estate will be able to satisfy large cash bequests added to his will at the very end of his life. And while it may be that many testators overestimate the value of their estates, Mr. OSUNA was a professional art dealer who had a very good idea of the value of his estate. And he knew that that estate would not have enough money to pay creditors, satisfy cash bequests that he added due 3 weeks before he died, and make provision for his husband in all but name, without reserving a portion of those sales proceeds to the estate. If there are no other questions, I would ask that this court reverse the probate court.
Okay, thank you very much.
Thank you, Your Honors.
Thank you both for your arguments today. Very interesting case. We will take it under advisement and we are adjourned.